I want to thank Julie for taking time out of her very, very busy schedule today to squeeze us in between this meeting and that meeting, and then also taking the time to do the research so she has some information to share with us. So I know you're tired of listening to me, so I am going to turn this over to Julie.
Sure. Great. Thank you, Kim. Can you hear me?
Yes.
Okay, great. Really crazy week in the world of real estate. Some surprising, lots of laws are at play right now. So I thought I would just take a little bit of time. If you don't know who I am, I'm a real estate attorney. I file a large number of evictions, foreclosures. Sometimes I repossess things, and I'm in and out of the bankruptcy court on behalf of real estate investors. I focus on right now, I'm focusing mostly on default cases. When I'm not that busy, because of all the defaults, I'm also involved in a lot of different litigation and transactional work. But today, I wanted to go over the new law that was just put into place today. It became effective this morning. So President Trump has issued an executive order halting residential evictions through December 31st for tenants who have been impacted by COVID-19. There's a lot of vague terms in this executive order. It's being interpreted extremely differently by different courts already, and it's just day one. This executive order is very controversial, largely because it wasn't passed by Congress. As you might know, our United States government is in a little bit of a crisis right now, and they're not agreeing on much of anything, which led to this executive order that was questionably written by lawyers. We're not quite sure. The goal of the order was to prevent the spread or further outbreak of COVID-19 because of homelessness. They're looking at national numbers, which is kind of unfortunate. We would be a lot happier if we were getting state orders that made sense for the area in which we own the real estate, but that's not what we have. So this order goes into effect today. It expires on December 31st, 2020, so at the very end of the year. It only applies to non-payment cases, which is pretty good. So we're still going to be able to get a significant number of bad acting tenants out of the premises without this impacting us, depending on the court. I think that's going to be, it's really clearly written that way, so we're hopeful. What is going to be required is that landlords send a notice to their tenants saying these are options that you can take, just living here essentially. Until December 31st, if you fill out this declaration/affidavit. I'm not very happy personally that they're putting the burden on the landlord to tell the tenant what rights they have. Unfortunately, that's just kind of the court environment that we're working in. Any tenant that wants to invoke this executive order has to sign the affidavit saying that they are unable to pay rent because of COVID-19, that an eviction would cause them to become homeless, that they've made every effort to obtain governmental assistance, and that they're paying as much rent as they can. There are going to be people that take terrible advantage of this executive order, but those are the criteria that they must say that they meet. The order says that we can continue to file evictions. I'm going to encourage people to continue to get in line. I think January could be a complete systematic meltdown just because of the sheer numbers of people, or it might turn out okay. We don't know. I do think that if you have tenants that fill out this affidavit and just are not paying, let's go ahead and file and get you at the front of the line. So at least by spring, we've got a court date and can be moving forward. You definitely want to be ahead of the line, not behind the line. If you fail to send out this notice to your tenants, or there's criminal penalties and fines that are pretty excessive in this executive order. If you try and use self-help, there's a lot of landlords right now who are saying, like, if the courts can't help me, I'm just going to change the locks. I'm going to take the front door off. I'm going to boot the car. I think the penalties in this executive order are far stiffer than anything that we've historically seen. I have an article about the new executive order that went up yesterday on my website, MO for Missouri, KS for Kansas, law for the law. So mokslaw.com under the forms tab. And I have it listed as federal executive order forms if you're going to try and do things on your own. Right now, most lawyers, like myself, we're kind of scrambling county by county. I spoke with 6 judges yesterday because this is going to impact the current cases that I was filing. I was hoping that, last night I authorized all overtime of all staff to try and get these cases on file yesterday or by midnight last night, hoping this order might not impact it. I think the courts are going to just interpret this thing so broadly that we're going to have to jump through some hoops. The CARES Act, which is also another federal law, has now expired. But if you are asking for back rent from the months of March, April, May, June, and July, in any cases, we're still having to comply if you have a federally backed mortgage or the federal government pays for any type of voucher or rental support for the unit at hand. Probably the most common question I'm getting is, I take Section 8 in one of my 20 units. Does that mean I have to comply? No, we only have to comply for that specific unit. Kansas, last week, or I guess now 2 weeks ago, also the governor handed down an executive order that's requiring landlords to prove that the tenant's default is not COVID related. I have been struggling with how to prove what's wrong with a tenant. My theory is that we send a letter, and I have a sample letter under Kansas executive order forms that you can send to tenants if you're in Kansas, requiring them to reply to you. And then you can say under oath, to the best of my knowledge, information, and belief, their default is not COVID related. I think from a business standpoint, this is a really tough blow on real estate investors. There are going to be some really bad acting tenants that are going to just take advantage of this and squat in homes. I cannot encourage investors enough. I think we just have to keep filing. I am looking into some ways in which I can depose tenants prospectively or conduct limited discovery under oath, making them tell me why they can't pay rent, what they could pay, taking a look at their financial situation, their employment records. Lying under oath to a court is a criminal offense. So rather than just throwing our hands up in the air saying, oh my God, no one's going to pay me until next year, and then the courts will be so far behind that I probably won't be able to get them out until early spring. I know there are a lot of investors that are just feeling panic right now, but we do have a number of things that we can do. It's my plan to try to work with tenants. I'm working with a couple of tenant foundations now on trying to get some rent relief for the tenants so that they'll pay the investors. Remember, I'm not trying to get the tenant paid. I'm trying to get the investor some rent while we're under this executive order. There's still a possibility that Congress could come back because they hate this executive order, and there's going to be some litigation about this executive order on a federal level. I have some personal issues as a lawyer with the thought that I'm going to have to give legal advice to tenants while I'm representing landlords, which is kind of what this requires, which is unethical for lawyers. So we've got lawyers all over the country really pretty peeved off. But again, I will just have to play this out. What I don't want to see landlords do is just say, woe is me, there's no relief for me, I'm just never going to get paid till March. I don't think it's going to be that bad. Questions for me?
Julie, you mentioned getting in line in early spring. Do you have any sense for how long the line is?
So depending on the county and the state, Kansas is still requiring us to do everything remotely. I feel like courts in Kansas, so Leavenworth, Douglas, Johnson, Wyandotte, they have pretty much worked through their COVID-19. They were under a moratorium in Kansas. So I think we've pretty much worked through any backlog. So I'm talking about cases filed in February, cases filed in early March. I feel like now in September, we've moved through all of those filings. On the Missouri side, we're not as lucky. Every judge in every courthouse is kind of beating to their own drum. We are seeing some pretty significant delays still. I have worked through now all of my pre-COVID, at least they're set for trial. It's pretty sad. I think some landlords are just saying like, I feel bad, or I want to work with my tenant, so I'm not going to file. And unfortunately, we had this small little window here in the last month and a half where people who didn't file, I mean, I feel horrible for them because they thought they were doing the right thing by working with tenants. Now we have this executive order, and there was just this little window where we could keep going. But that's the problem. Like, if you hold on to cases and just think, if you put your head in the sand, or you just think that maybe you'll be nice and everything will work out and not file, or fearful of filing, I don't know. I mean, if every single eviction in Jackson County cannot move, or if most evictions in Jackson County cannot move forward until next year, I mean, we would be looking at a multi-month delay, especially if we're still dealing with COVID-19 and having to go under social distancing orders. So what's happening in some counties is I can only have 10 people in the courtroom. I have to have people standing in the hall on these dots. You know, I'm only able to take so many cases, 4 to 5 cases every 15 to 30 minutes. We're seeing a significant increase of contested cases. Obviously, legal aid has hired 4 new lawyers to just deal with housing. So I'm seeing a lot of counterclaims, and just, I don't know how long that'll last. But if everything became contested come January 2, when we would get back in, we could be looking at 4 months. And again, I feel bad for people who are still dealing with unpaid rent from last year. But if you're not going to be an advocate for yourself, and you're not going to try to move your own rights forward, you're going to be at the end of the line, and the pain is going to be pretty bad. And I don't mean for this to sound self-serving. People can do this on their own. I'm not the only attorney in town, but I personally am encouraging my clients, let's get in line, because you don't want to be behind several thousand cases potentially. And again, one thing I hate about this case, or about this executive order, is that the courts are interpreting it to mean that the landlord has a duty to tell the tenants of these rights. And that's not what the executive order says, but we're just getting really strange
stuff.
Sure. Any other questions?
We have a question that was typed in the chat, and it's quite lengthy. How likely is the penalty or the fine going to hold up under this new law, that the person violating the order may be subject to a fine of no more than $100,000 if the violation doesn't result in a death, or 1 year in jail, or both, or a fine that gets larger if there is a death, and yada, yada, yada? How likely do you think they're going to start fining landlords and throwing them in jail?
Oh, I mean, I think the likelihood of all these government entities coming together to start some sort of subcommittee to start, imprisoning landlords there are going to be some cases around the country where they're going to make examples out of landlords, who are doing things, like I said, changing locks, taking off doors, booting cars, just illegally evicting people because they can't get relief from the courts. I'm still hopeful that we will get relief from the courts. We're just going to have to jump through 2 or 3 or 4 hoops. I plan on putting these tenants under oath if given the opportunity, and requiring them to bring in documents and proof that they've tried to do these things. I don't think just checking the boxes that they've done it is going to meet the court's requirement. I don't know how open the courts will be for us to do that. There will be some landlords, I think, that will be made an example of. This is a federal executive order, so it will be like the FBI, the federal, it will be
Homeland Security
investigations. So this is not going to be like, oh, the municipal court just gave me a ticket because of falling paint on the eve of my roof. This would be a far more serious undertaking with federal law enforcement, who are coming in under the CDC. There's talk that the mayor in Kansas City, and obviously we've seen very pro-tenant moves from the governor in Kansas, they might put together task forces to try to make examples and enter more local laws to try and find and make examples of bad acting landlords. More so now than ever, I know a lot of my clients with some properties, they'll do their own evictions, they'll take the law into their own hands and they do their own things. And if they need me, then they'll come to me. I don't think that's a very good idea this week. We need to see how things are going to kind of shake out in the upcoming 2 to 3 weeks. And I'm going to know a lot more. Just yesterday, like I said, I've spoken with 6 courts. 5 of the 6 have, only 2 courts are agreeing right now. Leavenworth does not agree with Douglas. Johnson does not agree with Wyandotte. Johnson now agrees with Jackson in Missouri, but Independence is not on the same page as downtown. What happened is they just kind of spewed out this executive order, and it's long, and we're missing a few words, so we don't know if there's a semicolon, but not an and. So we don't know if they have to meet all the criteria or if it's or criteria. There's some real strange punctuation in this executive order. They might have to hand down some advisory opinions in the next few weeks.
So here's a question. I understand that we can't evict somebody if they invoke their rights, but can we still file eviction on them for non-payment or other reasons? But we would halt the eviction if they hand us the form and says you can't evict me because of this.
So this executive order only impacts non-payment of rent cases. That means most tenants are also bad actors. I think really what landlords have to do is get more involved in how much trash is on the balcony, what kind of housekeeping, what kind of damages are they causing? Are they, any given day, and numerous landlords are threatened by tenants, we're going to just have to file cases based on behavior as opposed to non-payment of rent if we really want somebody out. In the meantime, we can keep filing. We should keep filing those non-payment cases. Historically, 80% of what I do is by default. So tenants who don't pay their rent and don't care to open their mail, especially when they get a letter from a lawyer, I might just get most of these 80% of these cases smooth sailing because they don't comply by filling out the declaration form. And the other 20%, some of them won't be impacted by COVID-19. Our employment rates are not that bad in this city. There are still a lot of people working. And like I said, I'm working with a couple of tenant organizations right now, and they're getting some federal money in. and they're going to be working with lawyers like myself and trying to help the tenants pay some rent. We might have to, if there are people that are truly, impacted by COVID-19, we might have to make some compromises and take some temporary hits until January, but that wouldn't be that bad. I mean, that's much better than, your worst case scenario, which I have a few clients. I mean, they haven't seen rent since December of last year, but then they didn't file until March. Then we were under all these executive orders that just expired, and now they didn't get their case in yet, and so we can't file. Or we can file, it's just I don't know if we'll be able to move forward. So I say, let's file the cases. The default rates are definitely on our side. The fact that your tenants don't open their mail, don't read, and don't fill things out properly. So those cases, we will just move forward.
Okay.
And there's some hope. I know some clients are very emotional, especially if you watch the news where they don't go into all these requirements about what the tenant has to do. It just says eviction moratorium all year. That's not really what this is. This is deeper than that. And anything you want to know about COVID-19, the CARES Act, the Kansas executive orders, the federal executive orders, I'm uploading articles and forms for landlords every day on the website under forms. I'm going to continue to do that. I think it's a much more effective way than just talking to my paralegal about the law. If you're emotional, just log on. Every time, the first link will be an article about what is the law, and then the second document in every category will be a form that complies with that law.
All right. We have some more questions for you.
Okay.
Do I have to give my tenant notice of the CDC information, and I think you mentioned that the law doesn't say they need to, but the courts are saying they think that they should be telling the tenants about the CDC law.
Well, if you're not going to file an eviction, there's no reason for you to march around, and be telling your tenants anything.
Okay, so as long as they're fine and they're doing their job and they're paying their rent, you don't need to rock the boat.
Right. Or if you're working with them, you're accommodating them. Hey, they took a hit because they lost their job for 30 days and they're on a repayment plan. Don't tell them anything. Don't tell them you can live here for free until the end of the year. Stop paying me, just move forward. But the courts, so far, 5 out of 6 courts are requiring the landlord, shifting the duty to the landlord to send the notice to the tenant, which is not what the executive order says. And I think that's what's going to be litigated, is that the courts are adding in this requirement that I, as an attorney for a landlord, might have to tell the tenants what their rights are and still represent the landlord. It doesn't feel right, but we're just this morning, I have this many new executive orders that have just come down in the last hour. So, I think the courts are going to make us tell them when we file the eviction that they could, they could do this. But again, if they're also behaving badly, have poor housekeeping, unauthorized dog, unauthorized occupants, threatening and poor behavior, drugs, disturbances, which is like every tenant. This law doesn't impact us in any way. We can just move forward with those.
So, but we can't really, if we're going to send a 3-day pay or quit or whatever it is on each side of the state line, do we have to include information about this law with our, hey, if you don't pay me, I'm going to evict you, and oh, by the way, I can't evict you?
That's what 5 out of 6 judges have said so far. Yes. And so we are recommending either you, the landlord, do it, and if you don't do it, then I'll do it separately. Then your lawyer who files the eviction will send it out. And I don't care which way we do it. I'm going to have to certify it was done. And I kind of prefer, I actually think tenants are less likely to read my mail than they are to read the things you post on their door. But I mean, it's up to you. I put the notices up there so that a landlord could do it on their own without me.
So we may not be able to evict, and we can't like go lock them out or turn off their water because that's always illegal. But would we be advised on some of our tenants if we could pay them to leave, to get some kind of form or document from you saying they agree to leave of their own free will and you paid them, like a cash for keys situation?
Yeah, I mean, I'm doing cash for key agreements. I've seen some landlords say, I'll pay for your moving truck and give you $250. And I have I'll draft up a little agreement, everybody signs it, terminating the lease, and then they leave. Now, if they speak with legal aid's going to tell them, oh, don't take that. I mean, just the value of sitting there until January for free is far greater than $250. But I mean, I don't know what kind of legal advice people are going to get. That's surely not what the notice that's coming out of my office is going to say.
All right. And then Angel asks, and this might be for you and for Stacy as well, how are we collecting the resources for tenants so that landlords can get paid? Do you have any resources to send the tenants to help get their rent paid?
So I have a form on my website under COVID-19 forms that it's called Tenant Resources for Dealing with COVID-19. Once the case is filed, I'm working with a foundation. So essentially, if they exercise this option, I'm likely going to be sending a list to the foundation, seeing if there's any opportunity for those tenants to get relief. Of course, they're going to have to actively participate by filling out applications and meeting with the foundation and getting tenants. As you know, if you're in this business, some of them are great advocates for themselves, some are horrible. And I can't get them to do anything. I can't even get them to move when the sheriff shows up. So, but there are resources. I add to this, I'm gonna pull it up here. Let me see. I've got about 15, 20 resources. You can print it out and give it to your tenants saying, and I think good communication with your tenants is a great idea, saying, it looks like you're struggling with your rent. Here's a list of resources. What can I do to help you? Here, call these people. They can help you get your rent paid. You're gonna have to work with them, possibly, or you still have an 80% chance that I'm just gonna get a default and they're not gonna respond. So I'm thinking that we'll be dealing with, in the whole scheme of all rent and possession cases, this will probably be less than 10% of cases that this executive order will end up. That's my estimation right now. I might come back to you because the media is going to pump it and pump it and pump it and say, wow, that went from 10% to 20 or 30. But the statistics are still pretty good with you that as long as we follow the steps that are necessary and file the right things, we still will be able to evict people. It's just if the tenants don't file the declaration, they don't open their mail, they don't come to court.
Because I see a lot of landlords, and there's a very long thread on Bigger Pockets about this, that they're just going to have all tenants and all leases be month to month. So if you're at the end of 30 days, whether they pay or not, you can evict them because their lease is over.
Correct.
That's going to work.
Yeah, this executive order does not impact unlawful detainer or forcible detainer cases where we've terminated the tenancy. So we've terminated it because it expired. We terminated their month to month, or we've terminated them for behavior, drugs, violence. I will still be moving forward with all of those cases. And it's not a bad idea right now, as you're entering into leases, to just put them on a month to month. hey, you're on notice that we've got some problems on the court side. So that's probably a really good idea.
Okay.
I mean, it's not the most stable environment for your investing. And I understand that. You want long-term, good-paying clients, especially if you're plan on selling. But month to month sound like a great idea to me right now.
Do you think that if we can get Congress to act and actually come up with something better, that they would rescind this? Or
I do. I think that at least on the listservs that I'm on, of course, with this coming down just in the last 48 hours, I mean, there have been thousands and thousands of legal comments from lawyers, you know, all over the country. I think that there's some real serious questions as to what kind of authority the CDC has to be entering these orders. I think the way that the courts are interpreting the order is not from the plain language. I could see some litigation. I could see, the problem is, do the real estate investors who are looking like wealthy people right now, do we have the power to make Congress do something in an election year that doesn't help the poor people, the poor? So I don't know. I mean, Congress can't agree on much of anything right now, but yes, there is a chance that I think that if Congress had come to an agreement in the last 2 or 3 weeks, we would have never seen this executive order.
well, I kind of think it was Trump said, okay, Congress is doing nothing. We have to do something, and I can't pass a new law all by myself. Here's this old law. Let's just use it.
Yeah, it's definitely a stretch, a pretty big stretch of the authority of that agency to enter such a comprehensive federal, and it is kind of a taking. I mean, when you think about it, they've pretty much said, we're going to take your property and give it to somebody who makes less than $99,000 a year. You can't do anything about it except, you know, they'll owe you the money later.
Right.
It's a temporary taking of your property. And it's contrary to the history of our country, what our country is based on, free enterprise. And it's a really strange time. Unfortunately, like when you try to take these cases, it wouldn't be me, but the lawyers that on behalf of investors that are trying to bring these cases to the courts,
It could be
does
years.
not look like a team player. We're not coming from the favored position. People are really attacking investors. They're definitely attacking me. On the internet, I've had demonstrations, and, you know, eviction is murder. I'm a murderer. I'm an agent of murder.
Yes.
And some other various comments. So it's a hard place to be in because it's so heightenedly emotional. And we're seeing that in court as well. You know, we now have to have deputies present in
I
court.
probably do, but
Yeah. People are really pretty upset about this housing thing.
I want to.
So if we're going to sign a new lease between now and the end of the year, is there anything you would recommend we put in that new lease?
Waivers of liability. You know, the last thing you want to have happen is that once, I've always said, you train your tenants to be good tenants or bad tenants. So if we're going to let some tenants live there for free for 6 months, I think there's probably going to be quite a sense of entitlement, which can often lead to injuries and accidents. So it's more important now that you have sufficient insurance, good, strong language as to liability, waivers of liability on the Missouri side, and any type of waivers that we are permitted to have on the Kansas side, and those are very narrow. Obviously, you're going to want to make sure your leases have attorney's fees provisions that are very favorable to you. Should you be sued, you can charge that back to the tenant. If you sue them, your fees can be recovered. a pretty strong provision in your lease that if they lie on their application or lie in their correspondence with you, that you can terminate the lease. That might be a way. I like that idea. And then again, I think it's going to be a business decision for you guys. Do you want these long-term leases anymore? Or do you temporarily just say, I'm putting everybody, you know, to the extent that you can on a month to month? I think it's a good idea. That way, if they stop paying you, we can terminate for other causes.
I guess I have to unmute so you can hear me. Do you have any thoughts on the rent guarantee insurance? I know really and truly it might help us, but it doesn't really help the tenant much. But have you any thoughts on the rent guarantee insurance?
So I do understand that I haven't actually gotten into those policies. I understand I have a few clients who have taken out this type of insurance. Sounds like a great deal. I will remind you that in the history of this country, we've had quite a few insurance companies that are not legitimate, that are not fully backed, and they just kind of fold up and go away. I mean, look in 2008, I mean, we had banks that did that. So this kind of strange, it's not a typical kind of insurance. So I kind of worry who's issuing it and who's underwriting it, and is it actually really anything? But if it is, great. Rent insurance sounds wonderful for you.
One county in Ohio has legislated that the landlord has got to include this renter's insurance from a specific company for all of their tenants. And basically the tenant pays for it. The landlord has got his rent guarantee. And then afterwards, the renter insurance company goes back and sues the tenant to get all their money back. So it doesn't help the tenant in any way. It just costs them more getting in. So I don't know.
Right. But if they're not going to pay their rent, they're probably also not paying their utilities, insurance, you know, late fees and other charges. However, if they're not paying their utilities, that might be a basis in which we can terminate their lease, because that would be a violation of their lease, and this executive order wouldn't apply to that kind of violation. So creative accounting, and I'm not even going to call it creative accounting, just accounting generally. Typical accounting should be that if you receive $1, it should be applied to the oldest rent balance. Another provision I'd love to see in all leases is that you apply any money received first to rent, the oldest rent due, and then to non-rental obligations. But if you don't have that provision in your lease, you know, I've seen such bad accounting from real estate investors sometimes where you're like, well, they didn't pay 4 months and then they paid $5 and then I put it towards May rent, not to the 4 months ahead. And I'm like, I don't understand. So good accounting practices, you know, I have a sample ledger on my, if you don't have sophisticated software and you don't have good processes and procedures, I've given you kind of a cheat sheet on accounting for real estate investors on our website.
All right. So do I have any more questions? I know you have to get going soon because you have a 10:45, I believe. So I want to give you a break there. I think we've gone through most of the questions. Have I missed anybody's questions in the chat? Speak up.
May I ask a question?
Yes, Stacy.
Okay, good morning. Julie, if we do decide that we want to notify a tenant that we do want to evict them, the documents that they must get back to us, can you talk about that a little bit? And must they be notarized? What should we get back from them?
So there's a form on the website called the COVID-19 Tenant Declaration Form. This was the earliest form that came down from the federal government that I've revised a little bit. And this one is approved in Kansas. I'll be putting a Missouri one up as soon as I read all of this. So within the hours. And it's just called a declaration that the tenant has to sign. And I've added a certificate of service, and I've added a little bit of explanation. I think it's a little strange to just randomly plop a form in front of your tenants without any explanation what it is, because they might just fill it out and it doesn't apply to them in any way. So that's up there, and it's saying, you know, telling them that there's this executive order that if they wish to invoke the order, they have to complete the below declaration and return it to the landlord. And they're having to declare that they've used their best efforts to obtain government assistance, that they expect to or have previously earned $99,000 or less in annual income, that they're unable to pay their full rent because of a substantial loss of household income, that they're using their best efforts to make partial payments, and that if they were evicted, they would become homeless, and that that they understand they can be evicted for reasons other than the non-payment of rent, and then they sign this and give it back to you.
It is not notarized?
It is not notarized. I think the executive order leans towards an affidavit under oath, but so far every form coming out of the courts, so all the court approved forms, do not have notary blocks on them. And I think they're considering, because of COVID-19, the need to find a notary or to travel to a notary or to become in close contact with a notary would be too great of a burden. I do believe that the executive order leans towards an under oath declaration, but not a single form coming out of any of the 5 courts have required that.
Yet you can
Okay.
get notarized at the bank drive-through.
I know you can, and I've had people doing it, but essentially any way that we're trying to stifle this or burden the tenants or put any type of roadblock in front of them, I think the courts are just going to throw it out. Frankly, after how emotional things have been in the courts, I can't speak for all judges, but I can speak for probably a few. They're relieved not to have to see these cases and not to have all these people from the public screaming and demonstrating and hollering and crying and carrying on. So partially, I think the courts just don't want to deal with this. But they're going to have to, because I plan on continuing to push. I'm going to push this as far as I can, and I don't exactly know how yet I'm going to do this, but I want, if I don't believe this is true, like if a landlord says to me, they returned this, but they've never tried, I know they're working, they're going to work every day. I know they haven't made any partial payments. I know this is false. I mean, I think that the landlord should be given the opportunity to get that tenant into court and prove to me how impacted you were by COVID-19. Everyone has been impacted by COVID-19, but that's not the requirement of getting free rent until next year. You have to show that you've contacted agencies. I want to know, what agencies did you contact? When did you contact them? What, you know, you said here in your declaration that, you know, you were impacted, but I know you're working. Also, if I can, never thought that I'd be working with so many tenant organizations, but once we start getting these affidavits back, I'm going to put them in front of the tenant organizations every week. I'm going to go in there as a lawyer and I'm going to say, can you help these tenants? Because it's going to mean money for the investor. So, you know, even if we have to do the work for the tenant to get them some money, in the end, I think there's money out there. And, you know, there's a foundation here in Kansas City, and they're going to have millions and millions of dollars worth of relief money for tenants in the upcoming few weeks. So I'm going to march in there and try and qualify all these tenants so that we can get you some rent.
Here, I got a couple more questions. As I understand it, if the resident sends the notice form to us as a landlord and we fail to get that in front of the court, and they get evicted or move in with grandma and get sick, that we could be liable to we could be liable for $100,000 to $500,000 for not providing the form and not following procedure.
Correct. You know,
Okay.
we're going to be filing, the courts are going to require us to file a statement with the court that we have not received it.
Okay.
And we have an ongoing obligation to update the courts as if we do receive it.
And this person's asking, should we maybe have a third party provide the form to the resident to prove that we did it?
Well, I'm going to do it. You know,
Okay.
I sat down with my staff this morning and said, do we push all this out? Do I write the clearest instructions? Send this, fill out this, do this, inform me of that. But at the end of the day, I have really sophisticated, wonderful, caring clients that sit on seminars like this and learn about the law. And then I've got some that I don't know where, living in la land, who don't follow instructions, who don't read my instructions, don't complete out my forms properly. And so I've decided, at least in the beginning, so for 30 days, I'm not even giving my clients the option. I'm going to say I sent it. I'm going to tell those tenants to send it back to my law office, and then I will certify as an officer of the court that I have not received it.
Okay.
And so that's how I'm going to deal with it for 30 days, because I think that's the safest for the landlord. So you're not going to get fined $100,000 to $500,000, $100,000 to $500,000 unless you want to take it into your own hands. I think it's safer with a lawyer, honestly. They're not going to fine me. I mean, every piece of mail that comes into this office is scanned. I have a camera on the front desk. So if they say they sent it to me on this date, I can prove everything that came in on that date. And that's a lie. You probably don't have processes and procedures like that. So yes, I think a third party wouldn't be a bad idea. I might become more comfortable in 30 days and start saying, okay, landlord, you can send it out as long as you send me a copy of what you sent. And then I will certify to the court that, to the best of my knowledge, information, and belief, based on statements from my client, this was sent on this date at this time and served in this manner. So in my form on the website, I've added a certificate of service that I would require the landlord, if they want to do this on their own, to fill out. And it says, I certify, landlord, that a true and correct copy of the foregoing COVID-19 tenant declaration form was served on blank date, blank time as follows. I sent it by US mail. I served it on the tenant personally. I served it on somebody residing at the premises over the age of 15, or I posted it on the door. Then take a picture of it on the door. I think that covers you. You sent it. Now, if they lie that they sent it back to you, that's a hard thing to prove. I mean, it's hard to prove the negatives. It's easier for me because I've got a camera. I've got a scanning process and procedure. And if you don't have that kind of procedure in your own business, maybe it's safer you just have a lawyer send it out.
Well, we are reaching 10:30, and I know you have to move on to your next appointment. We have recorded all this, and I'm going to share it out with everybody that's on the call and a few other people. So you're going to be all over the internet tomorrow, Julie, just so you know.
Oh. Luckily, this will be in a positive way, not in the she is a murderer way.
But I want to thank you for taking time out of your day for researching this and then sharing with us. I have one more thing you need to know. The Jackson County Sheriff's Department canceled all setouts for today. And going forward, I guess all setouts are canceled until we get more information. So
that's the information, FYI, that's right here. So if you're, I expect and have authorized essentially my staff to come in this weekend, and we are going to have to send these notices back to every case that's in queue. I, again, do not think that is what the executive order really intended, but that is the interpretation of the courts. So we are going to be getting these notices out here in the upcoming days, and then filing certifications with the court that we've done it so that we can get those writs rescheduled.
Well, all right. Well, I am going to say it's a little after 10:30, and I'm going to go ahead and end the call. Again, thank you very much on behalf of everybody on the call and everybody that's going to hear you. And everyone on the call, I will be sending you a link to take action and tell your legislators that we would like them to do something else besides this. And if you haven't already done that, please take action today once you get that link. Again, thank you, everybody, and I will see you all at the meeting next Tuesday.